Hi, I'm Tim Naftali. I'm director of the Richard Nixon Presidential Library Museum in Yorba Linda, California. It's September 29, 2011, and I have the great honor and privilege to be interviewing Evan Davis for the Richard Nixon Oral History Program. Evan, thank you for doing this.
My pleasure.
Give us a little bit of your prehistory before you joined the inquiry staff.
I was born in Manhattan, so I'm a real New Yorker, but when I was very young, about a year old, I was yelling and screaming so much as a kid in this small Manhattan apartment that my parents felt it was really important to move to the suburbs. So we moved to Connecticut when the suburbs were really quite rural, and I grew up in Riverside, Connecticut. I went to public schools in Riverside through junior high school. And then the high school in Riverside was this building that had 6 or 7 stories with 3-minute or 4-minute passing periods between classes. And while at that time I was quite good at going up and down stairs on crutches, I was not going to be able to do that in 3 or 4 minutes with crowds of high school students. So my parents thought I should go to a prep school, and I went to Exeter. And I was at Exeter for 3 years. And I had to climb stairs there too, but the schedule extends through the day and it was easier to organize. I enjoyed Exeter a lot. I often think today most of what I know really comes from Exeter because I actually worked hard at Exeter. Law school too, Harvard not so much. Then I went to Harvard and graduated in '66. I went to Columbia Law School, and I enjoyed law school a lot, and I became editor-in-chief of the Law Review and did well at Columbia. And I first went to Clerk for a judge on the DC Circuit who was a former Columbia student, also had been editor-in-chief of the Law Review. Every year took a Columbia clerk, Harold Leventhal. Harold Leventhal was an interesting judge. He'd been involved in Democratic politics, had been the lawyer handling the Fannie Lou Hamer issues of the seating in the Democratic Convention. He'd been an oil and gas regulatory lawyer, Federal Power Commission lawyer in Washington, and became a wonderful circuit court judge with a specialty in administrative law. So I clerked for him for a year, then I clerked for a year for Potter Stewart. Potter Stewart had been involved in Republican politics. His father had been mayor of Cincinnati. He himself had run for the Cincinnati Council. He'd practiced law in New York City. So Harold Leventhal from the Democratic side and Potter Stewart from the Republican side were both similar in their approach to issues, in their love of writing, for example, and crafting opinions. So it taught me that there is a little bit of a difference between judging and politics. These people came from 2 very different political backgrounds. Getting a clerkship on the Supreme Court is a total lottery. There are many, 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 many people qualified to do it, and you're just luck, and I had the luck to get to clerk for Potter Stewart. After that, I went to work.
Can we stop for a minute, please? Because we've actually had an opportunity to ask somebody else, Professor Fiss, who clerked. What term did you clerk?
I clerked the October 1970 term. We had some very important cases. We had the Pentagon Papers case. We had the Cassius Clay case. We had some federalism cases of importance, Younger versus Harris. We had a very important segregation school busing case, Swan versus Charlotte Mecklenburg. We had a very important gender discrimination case, Griggs versus Duke Power. We had very important First Amendment cases. I happened to be there during a very interesting year on the court. They're all quite interesting, but mine was especially interesting.
Would you like to preserve some of your recollections about the Pentagon Papers case?
It's a little bit off topic, but
It's part of
I know the justices did not feel comfortable with, at least Potter Stewart did not feel comfortable with meshing the demands, the legitimate demands of national security, with the open transparency of the judicial process. I think as the case progressed to higher and higher levels, the government was willing to provide more information about what it saw as securities concerns. And this information of necessity has to be provided in a very secret way. So for example, the law clerks were not allowed to look at this evidence. The justices had to view it individually. And I think that raised discomfort. And I think it helped move Justice Stewart and some of the other judges to the conclusion that the government should be cautious in designating things classified, but when they designated them classified, should take every conceivable step on their own, because once the cat was out of the bag, it was going to be very hard for the judiciary to solve the problem for them. So that was a basic attitude I think the justice had. I think it's reflected in some of the concurring opinion. Everyone wrote their own opinion. It was, in that sense, a difficult case because it didn't really fit the typical judicial process.
Given its importance in the history of civil rights, could you just comment a little bit on the Mecklenburg case?
That was a case where I think the judges were more than usually inclined to defer to the judgment of the trial judge, the district court judge, because the district judge was there courageously defending the Constitution in a difficult circumstance, and I think they maybe bent over backwards to support him in the courage of his defense of the Constitution.
What comes next for you?
So then I went to work for the New York City government. I started out in the budget division, where I was the first person to be general counsel of the New York City Budget Bureau, as it was then called, now called the Office of Management and Budget. And after a year there, the Corporation Counsel brought me up to be the chief of the Consumer Protection Division in the law department. So when I went to work on the impeachment inquiry, I left being chief of the Consumer Protection Division to go to work on the impeachment inquiry.
Tell us how that happens. Who calls you?
So I had this job through the Lindsay administration. Norman Reddick was Corporation Counsel, a guy I admired a lot and enjoyed working for. And Lindsay, his term was over. Abe Beam had become mayor. And I wasn't, violently opposed to Abe Beam in any way, but it just didn't seem it was going to be quite so exciting. I did not have a political job. I served with the pleasure of the Corporation Counsel. Adrian Burke, a former Court of Appeals judge, had become Corporation Counsel, a fine guy, and there was never any sense that he wanted me to leave. But I thought maybe there'd be something more exciting. Particularly, I had some friends who had started working on impeachment. Jan Orloff, married to my law school roommate, was working on impeachment. A classmate from Columbia Law School, David Haynes, was working on impeachment. So I just decided to send in a letter. And I wrote my resume, put it in an envelope, and mailed it to the House Judiciary Committee. And about 4 or 5 days later, I got a phone call saying that Bob Sack was going to come to talk to me. So there in my office in the municipal building, Bob Sack appears, and we chat, and he must have given a fairly good report, because the next thing was to talk to John Doar. Went down to Washington, talked to John Doar, then I was hired. I started, I remember, shortly after my birthday. My birthday was January 18th, so a little bit after January 18th I started in Washington.
What do you remember of your interview with John Doar?
Not anything too specific. He wanted to know about my background. He asked the kind of questions that you've just asked about my life story and how I'd gotten to where I was. I believe he asked if I had any preconceived notions, and I said I did not. He asked about my job and the kind of cases I had, as I recall. I don't recall it being a very long interview, 20 minutes, something like that. And I don't recall more beyond that.
So you get the job, you move to Washington. What's your first assignment?
So the first assignment, after I get moved in, I move into a little room at the Congressional Arms apartment, a sort of furnished apartment kind of thing, and stock up the refrigerator with food, thinking I might cook something in the kitchen there. The food was never touched. At the end of the time I was there, the food was still in the refrigerator because there was no time to cook anything. So I get there, and I think my first assignments, I don't remember particularly, but I think they were organizing a group that was going to pore over the record as it existed, the various hearings that had been held, particularly the Senate Select Committee hearings, and to digest and absorb and learn very well this record. And there were 5 or 6 younger lawyers who were going to be doing this, who were going to be putting it into a chronology, making lists of things, thinking about the testimony. And I was put in charge, and I think it happened fairly early on, of this group of young lawyers digesting the current record and putting it together. And that process continued for 3 months, something like that, getting all of those papers together, and then we started writing memos about this material and what it showed, and we started thinking about additional information that would be required, and we started thinking about witnesses that we might want to interview, but the start was definitely, particularly I remember, the Senate Select Committee hearings, green volumes, and there were, I don't remember the exact number, maybe 10, each about this thing.
How did you know what you were looking for?
Well, I wasn't so much looking for any particular thing, but wanted to fully understand what everyone had said. And then I would see what emerged from that as relevant information relating to the president's conduct in those instances. So I think I read the testimony of some of the key people like Haldeman and Ehrlichman and John Dean, a number of times. And we also were working at the same time thinking about what was an impeachable offense. And Joe Woods did a lot of work on that topic. There was a memo written, I don't remember the name of it, but it was a fairly elaborate memo about what was a reason for impeachment. And so that sort of meshed into what I was doing.
May I stop you there? That Bill Weld and Hillary Rodham worked on that. Did you participate at all in that process?
I participated in discussions. I did not participate in the research. I remember discussions about, for example, whether we were talking about, obviously what high crimes and misdemeanors means in the Constitution, that phrase. I remember talking about, and my having a view, which I think others shared, of the need to read that phrase in connection with what the Constitution says about the duties of the president, particularly to take care that the laws be faithfully executed. And so that high crime or misdemeanor, I recall thinking personally and discussing with others, could well be something that a president was uniquely able to commit, a constitutional crime that the president was uniquely able to commit because others didn't have the obligations or the power that the president had to essentially subvert the Constitution, and that therefore defining the constitutional crime of high crime and misdemeanor would take into account the functions, roles, duties, and powers of the president. I remember personally feeling that we should set the bar high, because I felt that, remembering back to my government courses and all that kind of thing, that the president needed substantial room for independence of action, so that it had to be something very, very serious, of the same kind of seriousness that a statutory crime would be, but that it couldn't be defined simply as a statutory crime because it was a constitutional crime given the role. So I remember talking about it having to be serious, it having to be to some degree persistent, it having to have not a public purpose, the subversion of the Constitution, but some kind of private purpose would compound it. And I remember us talking about the standard of evidence and thinking that it should be a high standard of evidence, of proof, because, well, for the same reasons that, to use a very parochial example, when lawyers are disciplined for misconduct because you lose your job and your livelihood and everything, you get disbarred, it's clear and convincing evidence that's required. And it's not protecting the lawyer unduly, but it's just recognizing that the lawyer has to have room for zealousness and the advocacy of a client. President needs room, so it should be a high bar. Those are the kinds of discussions I remember. But I did not do the research. Others did, and I did not draft the memos. But I did participate in those kinds of talks.
For us to get a sense of the staff, because there were over 100 of you, these kinds of conversations, there was a senior leadership, and did they include others? I mean, it wasn't all 100 of you, or I think you had about 40 lawyers. It wasn't all 40 lawyers. These groups, were these informal groups over lunch, or was there, did John Doar put together a group of lawyers that would discuss this kind of thing?
I think some of it was at the level of kibitzing. There was not an anti-kibitzing rule, and of course with all these interesting topics all around you, you do want to kibitz. Secondly, the work that everyone was doing was interrelated. Knowing what you were looking for in the factual record was obviously tied to how you were going to think about what might be an impeachable offense. So you could see whether evidence existed of that kind of offense. So there was a need for everyone to be, I don't recall it being meetings in John Doar's office particularly or anything like that. I recall more informal meetings, but people would get together to talk about these issues. I remember attending meetings at which Owen Fiss and Hillary and others were present, even though that wasn't my area, to some extent to listen, but also to volunteer my own thoughts.
When did you start to focus primarily on the Watergate side of the issue as opposed to abuse of power, agency abuse?
Very early on. My assignment and the assignment of this task force that I headed up was Watergate and the cover-up. That was my assignment. And I was not. Another person who was very active in the same area was Dick Cades. And Dick had a broader role. And Dick did a lot more over the period. You know, we're talking in total about 6 months. That this was, it seemed like in many ways 2 years, but it was only 6 months. And during that 6-month period, Dick did a lot more conferring with members and going over information with them and answering their questions, members being members of the committee. I did not do that. I worked with this group within the staff on the Watergate and the cover-up. So I looked at the evidence, I participated in talking to relevant witnesses, I participated in drafting articles of impeachment related to that topic. But that was my topic.
What did you know about it starting out?
Well, the thing I mean, before I came. Obviously, you know, I've read the newspapers. I particularly remember it's one of those, and not on the level of, you know, the assassination of President Kennedy or the Challenger crash, but at a level not too far below that, the firing of Archie Cox. I remember listening to television, watching on the radio, and feeling that there needed to be continuing process, whatever it was going to be. And you remember that incident, you know, when first one and then another Attorney General resigned. It indicated a serious problem. So that's what I remember mostly. I was by no means a buff of Watergate facts. I was a consumer advocate. I was one of probably the youngest division chief in the history of the law department. So I was on a learning curve in that job that was stressful. And I was, arguing consumer cases, doing antitrust cases for the city, and learning a tremendous amount. So I didn't have time. But I think one of the things that when I decided that impeachment would be an interesting thing, I thought about, at least subconsciously, you know, helping to fill the gap created by the firing of Cox, to have a process that would provide the public with some kind of resolution.
The viewers of the Senate Watergate Committee were faced with the dilemma. Were you going to believe John Dean or Richard Nixon? Which is a very tough challenge. You know? When you started out, because you didn't have any tapes when you started, as a lawyer, how to make the case that, or at least to figure it out, because you weren't quite yet making a case, how were you going to think through the process of finding the president or John Dean the more credible witness?
So a lot of what was done in the beginning is to look at the testimony of all of these witnesses and find the points of intersection or contradiction, corroboration or contradiction, and particularly focus on points of corroboration. And those would be pretty hard factual elements because they were corroborated. And see what picture was painted by the corroborated points, where Haldeman's testimony or Ehrlichman's testimony or Dean's testimony was consistent. And we did have certain things before the tapes came along. We had logs, we had meetings, we had public statements, we had the like. And my recollection too is the tapes came along fairly early in the process. I can't give you the exact date, but it was fairly early. And in terms of watching the Senate Select Committee the summer before, I had occasionally watched it. I think I don't remember watching John Dean's testimony. I do remember the news flashes about Butterfield's testimony, because that was very dramatic. I didn't happen to be watching it, but it was on the news, and it was certainly, and the headline in the Daily News, Nixon bugs himself, that's I noticed that headline, as a lot of people did. But when I got there, I was trying to grasp these facts, focusing on where people agreed and where they disagreed, and if they disagreed, how you could resolve it, but where they agreed, what kind of picture did it paint? What did all these factual data points add up to in terms of the kinds of inferences they would support? Obviously, absent the tapes, there was a lot of circumstantial evidence. But if you add up all the circumstantial evidence in one circumstance after another points in the same direction, then it becomes weighty evidence. It can become clear and convincing evidence. So I did that, and we all worked very hard on it, and then at one point, I was able to talk to John Dean and interview John Dean, and I felt he was, truthful but looking out for himself. That's the way I felt about John Dean. And of course, his performance giving that account from memory, and then when it was compared to the tape, being so accurate was rather, my memory is not like that at all. I could not have done that. I just have, but the tapes did corroborate what he said, but still, meeting him, I felt that he was, focusing on his own interest, but his own interest coincided with his accurately recalling the meetings he had been in.
How helpful were the materials from the Watergate Special Prosecution Force?
They were somewhat helpful, but the special prosecutor had a slightly different take on things than John did. John was very good friends with Hank Ruth, who was a very important person on the special prosecutor staff, and they'd gone back to civil rights days, I think it was, maybe even the Neshoba County case together, but they knew each other well, and John had a lot of confidence in Ruth, and I think Ruth liked John. But Hank Ruth, as I heard it, I did not participate in these discussions, but I recall John saying that Hank Ruth felt that the thing was to prove airtight a criminal obstruction of justice, one incident of clearly obstructing justice in an airtight way, and that the special prosecutor people felt they had done that with regard to the money on March 21st. The Howard Hunt's going to blow if he doesn't get the money thing. And they felt they'd built a very strong case, including against the president, as I think they may have referred to him as an unindicted co-conspirator or something like that, on that. And John didn't agree with that on two counts. First of all, he was not infatuated, and this comes across in some of the reports and so on, with the notion that a president is a co-conspirator, because the president has so much power that really in a conspiracy, it's just that one person agrees with another to do a wrongful act and then does something to further their agreement. Well, that's not the way John thought the White House or a president worked. The president was the person in charge, and these people were his agents, and he didn't see criminal conspiracy law as relevant. The other thing, though, was that he did feel, too, that impeachment, because of our feeling that it was a constitutional crime, but had to have the seriousness and persistence of it. It had to be something more than just one event. Because taking a president from office is such a major event and potential blow to the country, and everyone would agree not to be done lightly, at least at the time. No one thought it should be done lightly, that there had to be something of a persistent problem that went over time, that didn't show an error that was transitory, but something, that went on. So John felt that there had to be a pattern or picture, I don't recall the word he used, and I agreed with this too myself, that there had to be some kind of pattern. So the special prosecutor, being prosecutors, you prove someone committed a crime on March 21st, you said this and that, and forward it went, and that we felt our task was different, to see whether there was this kind of pattern of persistence. So that's one reason why we kept the focus not just on March 21st, which was certainly a factor, and as you know, we cited to the committee the difference between the way the president ruminated in his nightly recording about what he had learned on March 21st and what he told Henry Peterson the next day about the situation. And that if he had told Peterson what he had learned, Peterson, could have prosecuted people. So that was not irrelevant. But we looked back, and we looked back hard, and I looked back hard at what happened in July. The break-in was in June, and the president was in Florida, and he came back to Washington, and there were a series of meetings, and various things happened. And there was a lot of agreement about what happened in the Senate Select Committee testimony that created a picture of, albeit at that time, circumstantial. The direct evidence more being in March, but circumstantial as to what went on. And I recall, too, that there was also, in the musings that went on later, the president reflected back on what had happened earlier and had referred to the plan of containment as having been the right plan. And so the word containment is just a fancy word for, or a more, not fancy word, a more, less negative word for cover-up, because containment means you're protecting certain people. And so we view those reflections as evidence that, combined with the circumstantial evidence, ultimately we thought created a picture all the way going back to June. And my big thing that I remember, the one, in 6.5 months, when the amount of work we did was so great that it does cloud your memory a bit, because your memory becomes selective with so much happening around you. You just select things to remember, and there's a lot of things that you can't keep in your head. But one of the things that I've always remembered is how firm I was that we had to get that tape of the conversation between Haldeman and the president. There was one on June 20, I think it was, where the 18.5-minute gap occurred. So, no matter what you proved about the 18.5-minute gap, there was a missing piece. But then there was another meeting shortly thereafter, and we had to get that tape, because that tape would indicate whether the would be direct evidence to either support or refute this reminiscence evidence and the circumstantial evidence. And so ultimately that tape was ordered by the Supreme Court in the special prosecutor case. And it said just what I thought it was going to say. I thought that the circumstantial evidence was clear and convincing, and that therefore, it's like the old story they tell the jury, that if someone comes in with a wet umbrella, you can infer that it's raining outside. And this was the equivalent.
Let's help the viewer. The challenge for you was that you knew from General Walters that the CIA had been asked to tell the FBI not to investigate the Mexican money and Kenneth Dolbrook. And you knew that the President's Chief of Staff, H.R. Bob Haldeman, had asked the CIA to do this. And you knew that Haldeman and Ehrlichman and the President had met to discuss this. But you couldn't prove that
what was said.
That the President had actually said to them, do this.
And there was other circumstantial evidence going on, and then the reminiscence of how the right plan had been, what they did, and to contain it, but you didn't know the exact words. You had, I would have said you had enough to be quite clearly and certainly sure myself, but you didn't have what's called direct evidence.
But again, to probe, because it's important, this is because you and Mr. Doar, and you weren't alone in this, felt that someone of Haldeman's stature would not be asking an agency to do this unless he had the support of the president.
Right, and more than just that one fact, that the follow-up facts supported the notion of a policy and plan of containment of this problem directed by the White House over these following months, and that evidence suggested that at such an early on meeting, this plan would be formulated, and that the president, who would be in meetings with the people who implemented a containment plan, would be aware of or direct the formulation of the plan of containment.
Because the assumption was that this kind of plan of containment could not have happened without the president's involvement.
Particularly since there were these meetings right at this time, and then immediately after, various things began to happen, and then other things happened. So it again, it's a picture. I remember one of the things I did towards the end was I prepared a list of 50 events between June and the following 4 or 5 months that were, I thought, only explicable in the context of presidential involvement. And I couldn't find any events that could only be explicable in the context of no involvement. So 50 items I felt was strong and justified justified going ahead and drafting articles of impeachment based on Watergate and the cover-up, finding that the president subverted the Constitution by orchestrating, approving, and condoning the plan of containment for his personal benefits.
The president would later point to a conversation he had with L. Patrick Gray on July 6th, 1972, as evidence that he wanted the investigation to go ahead. I guess this is the conversation where he says, where Gray warns him that there are people in the White House that are trying to set the CIA against the FBI. What was it that led you to see this particular conversation as not dispositive, as not evidence of the president's interest in the investigation going forward?
Well, we knew, I don't recall whether it was that discussion with Gray or a later one, but we did know in connection with one instance where the president called up the director of the FBI and told him to press forward with all vigor, that the president had a lot of information that we knew he knew that would have helped the director of the FBI press forward with all vigor, and he did not convey that information. So that raised the question of whether these were words that he just wanted to be able to quote, because if he really wanted the investigation to go forward, he could have provided information that would be very helpful.
Do you remember when you listened to the tapes the first time?
I did not do a whole lot of it. Obviously, I listened to the tapes. How could you not listen to the tapes? But we had a very careful process for listening to the tapes that I was not involved in. And basically, we felt that since the members were going to come over individually, and they did come over individually, to listen to the tapes after they received our transcripts of the tapes, that it was very important that when they listened to the tape and looked at our transcript would be accurate. They would say, yes, this transcript is accurate. And that was important because we prepared at some point a comparison of our transcripts with the transcripts produced by the president. And there were very material differences, very important differences. So the importance, evidentially, of our transcripts being correct was key. So the first idea was that people who had a good ear for music would somehow be able to listen carefully. Well, that really didn't bear out. So what we did is we had a system, as I recall, we had 3 people who would listen to the tape, and all 3 had to agree. I believe one was on the Republican staff, too. I don't remember their names. But in any event, all 3 had to agree that that is what the tape said, or before it would go in the transcript. So that was a process. So I obviously read the transcripts that were produced, and I think we were involved in a little bit of doing this comparison between the White House transcripts and our transcripts. And of course, you notice funny little things. So when President Nixon went on television to say that he was releasing these transcripts, he had all these volumes piled up behind him on a credenza, and it looked like it was thousands and thousands and thousands of pages. But when you get the notebook, some notebooks would just have a few pages in it. And I also recall that in some of the transcripts they produced, there were aside remarks that someone had made that got transcribed that were sort of you questioned, because it would say something like, take that out, or whatever. But that could, of course, just been because it was felt to be non-responsive or irrelevant. But it was sort of funny that that got transcribed as well. But the main thing was the differences, the substantive differences between our transcripts and their transcripts. So given that this issue was going to be important and would be influential, likely with the members, we did a lot of work on the accuracy of the transcripts, and my recollection is that members came over and listened and felt that what we had transcribed was correct.
Now, was the transcript or the tape the record? I mean, if you were trying a case, which is the record? So
the tape is the official thing, and that's why the members came over to listen to it, as they should. But if they feel that the transcript is validated, it then becomes easier for them to use the transcript. So of this interview we're doing, the tape will be the official thing, but if someone ever does a transcript, if it is valid and people look at it and it seems to conform to what you said, it's a substitute. So we worked very hard to be sure the transcripts were accurate. And it was just another aspect of a very important theme was the members did not want the staff to take over the fact-finding and the investigation. They felt that was their job. That's one reason they would come over to listen to the tapes rather than just take our word for what they said. And that is also why we use this phrase, as I recall at least, summary of information. We gave them these books with summaries of information, and it would have a statement of a fact, and it would have evidence that was confirmatory of the fact stated. And so a lawyer would normally call these statements of undisputed facts, because we tried to keep them undisputed in that they were corroborated by many sources. But the members felt it was their job to find the facts. And so by using a more neutral phrase, statement of information, it would be respectful of their right to go and look at the sources that were listed, the record, as you put it, and make their own conclusion on whether this was a fact or not a fact. So that phrase and these books I know came out to some extent of the way John had done cases in the Civil Rights Division, but that phrase, summary of information, I recall as being deferential to the members. And that was an important thing from the staff point of view, that we were to provide them with materials and they were to draw conclusions, and then we were to provide them with a way to implement their conclusions in terms of drafting articles and the like.
Do you remember some dismay on the part of the staff when the members didn't quite embrace the concept of statement of information, when they thought this is a little complicated?
I remember there thinking it was quite boring. One of the things I did was to be the reader of the statement of information. So we started the hearings, you know, with these books, and they all had the book and everyone there. And I remember there's this picture on the front page of the New York Times with the committee up here and this table with staff members here, taken with a little bit of a wide angle lens, so it's all sort of bent around. And there's John, and there's me sitting next to John as the reader of the statements of information. So, and I would read it on June 17th, 1972. There was a meeting between the president, and this was discussed. And the statement that such and such was discussed would be based on various participants in the meeting, not just one, not just John Dean, all agreeing in one way or another that this had been the topic. We didn't have exact words in a lot of cases, but, and the members did get impatient. John's biggest challenge, he has told me, was the pressure to do it fast. We ended up taking, as I said, about 6 months. And there are a lot of people who would want it to be done much shorter than that. But John felt that it had to be done right, that it had to be a thorough look at what the record showed, that it, and I remember our feeling strongly that whatever conclusion we came to, it was important that it be solid enough so that it would attract bipartisan support. And even before the smoking gun tape, we did get significant bipartisan support in the committee for the cover-up article, and for some of the other articles too, although I don't remember them as well. It wasn't what happened after the smoking gun tape came out, and basically all the members were supportive of the articles. But we wanted this to be, and John wanted this to be, as I recall, a constitutional process, so that you could say at the end of it, the Constitution has a mechanism to deal with abuse of power and subversion of the Constitution in a serious way. And it has a mechanism that works. And the mechanism obviously has a political component in that the public's feeling about how serious this is a relevant factor. And the members know how the public feels. That's their job, to be in touch with the public. So it has that component, but it has a component of fact objectivity to preserve the power of the president, which is equally important to preventing the abuse of the power of the president. So we felt that was really, really critical. And I say we, it doesn't mean all 100. I don't know all 100, but I know that it seemed to be a consensus among the staff that we wanted to do that kind of job that would be bipartisan. And so just a vignette that comes to mind is after the impeachment. I had friends who traveled around the world giving talks for the United States Information Service. And at that time, the United States Information Service had a program of people Americans, businessmen, whatever, would go and give talks at American embassies in various places around the world. They wouldn't pay your travel, but when you got there, they would arrange for you to give the talk. So you paid the airfare and the hotel, and they arranged for you to talk, except in India, where the United States had accumulated all this rupee balances under the Food for Peace program. So there they would use that to pay your hotel bill. But you still had to get to India. And so I had these friends who went around the world giving a talk. They were experts on devising modern waste collection mechanisms in big urban areas. The routing of garbage trucks was their specialty, the efficient routing of garbage. And they were very popular because all these cities have big problems with the routing of garbage trucks. So after the impeachment, I wanted to take a trip. And so I contacted the Information Service, and they sent me to, they arranged for me to give talks in the places I wanted to go. And the places I wanted to go to Iran and India and the United Kingdom and England. Those were the three places. My friends had been to Iran. They told me it was beautiful, Isfahan, all. So those are the places I went. And the Information Service said, we're very sorry. No one wants to have you talk in Iran. It conflicts with the program our embassy is putting on the American Wild West. And of course, I had forgotten, you can be so naive, that our ambassador to Iran was Helms, Richard Helms. The last thing he wanted was, people talking about, as you said, that the president had told the CIA to, so that wasn't his favorite topic. So no speaking in Iran, the American Wild West. But in India, they booked me into parts of India that were quite anti-American in their traditional. Kerala state in the south is communist state. And my message was, the system works. The system works. And it was, they couldn't dispute it. They couldn't touch it. So the embassy loved this because it was such a positive message about our constitutional system and how it works. The only problem I had in India is that sometimes after my talks I'd be approached by a group who was interested in impeaching Indira Gandhi, and they would come up and say, well, maybe we could talk, which of course I wouldn't do. But it was basically that the system worked, that it was not seen as just a political thing, that basically a serious inquiry had been made and a determination had been made about what was necessary to properly sanction with impeachment, should it have gone forward through the Senate, someone who had subverted the Constitution for their own purposes.
Let's go back to the period just before the committee votes. You spent 6 weeks reading the statements of information.
Is that how long it was? Was it 6 weeks?
6 weeks. 6 weeks.
Oh, that was longer than I thought. All right.
By the way, why was it decided to read it? Do you know why John Doar
I don't
decided?
know why we read them. I think it was just to get the sense that this record had been put before the committee in a way where they could read it and study it and confirm it. And if you just handed them the books, that wouldn't be totally satisfactory because it might not read them. This is like introducing evidence in a trial. When you introduce evidence in a trial, you have a document or a piece of information, you do either read it to the jury, you do what's called publish it to the jury. That's the technical legal phrase, which can either be reading it or handing it to them, and a pause is taken in the court proceeding while they read it. And so I don't recall the specific reason, but I think it was sort of this idea that we should publish this information to the committee.
Did you read the documents?
No.
So
no,
they
we read
were...
so the notebook, you'd have the statement of information. Then behind it would be the documents. So you would read the thing, and there would be time for them to be flipping through and looking at the documents. And each document was marked with a big black bracket to show the part that was relevant to look at, to corroborate the statement made in the statement of information. But beyond that, I can't remember why we read it.
Do you remember Mr. Doar's reaction to the fact that this was going to happen on television?
No, I'm sure it wasn't the world's most exciting television. There did come a point where the committee members started to discuss that was very, I mean, we all remember Barbara Jordan's impassioned in her voice of almost like the Grand Canyon as a metaphor for time. Her voice had that, and a number of other people on on all sides. That was a very good debate. And I was there, obviously listening to it. I remember that, but the other I don't remember thinking about whether it was good television or.
Do you remember Dick Cates's role in giving seminars to help the members absorb this information?
Right. I did not participate in any of those. Dick Cates's office was right near mine, and he was aware of what we were doing and what we were working on, and with the memos that we would write and all that kind of stuff. But my group, we did not have contact with the committee the way Dick did, and Dick played a really important role in helping the members work through the information. I know that John has referred when I talked to him, obviously I've talked to him recently, and he has referred to Dick Cates as a hero in what he did of helping the members come to an understanding of their own understanding of what the facts were, but helping them grapple with them, because it was, a complex factual story. Also, Dick, I don't know the details of this either, but I believe some of the permanent staff for Rodino were unhappy with the pace and so on by John, and Dick, I think, helped immensely in calming down that. I don't know the personal element of it, but I think he helped immensely. He had been hired, I think, independently, not by John, but by the committee, and so he had this slightly independent role that made him just a very constructive force.
And he got along well with John.
He did. He did get along very well with John, and they were both Midwestern litigators. And Dick, I remember, used to love to tell war stories about his cases. So we did find time to hear a fair number of Dick's war stories, of things he'd won that, were hard to win. And from all these guys, Dick Cates, but particularly from John, I learned so much about how to litigate cases, in the sense that from John, particularly what I learned was that it's not for the lawyer to be the star. It's for the witness to be the star. It's for the people with the factual knowledge to be the ones who convey their convictions and of what the facts were. And I think Dick had the same kind of attitude, not the flamboyant, lawyer, but the guy who works with people to ferret out the facts. I remember Dick told me, when you're trying to find out what happened, you've got to go and sit in somebody's kitchen and talk to them in their kitchen, with a cup of coffee about what went on, and not just bring them to their office and put them in a chair, and you've got to really. and you got to make them the subject. And the other thing, so I learned that John agreed with that totally. That was his approach as well, to be the lawyer in the background. And I've found in my career that sometimes the lawyer who gets congratulated for being the great lawyer by the jury is the one who's just lost. The other thing that John taught me, and that impeachment taught me, is the merit of close attention to facts and testimony, such that you find things, either points of agreement or disagreement, or sometimes things not said, like when Nixon did not tell Gray, President Nixon did not tell Gray what he knew. And that requires close attention to records and documents and testimony. And in today's litigation world, it's hard to do that because of emails. Emails just generate such a mass of information that it's too much. If we had had emails, can you imagine if we had emails, impeachment, it would have been 6 months wouldn't have been enough time. You can't digest. But you have to do them today because they often contain critical evidence. But it's just that attention to detail. And that's why I think John felt it was important to take the time. Because you can't do this, in a month. To do this right, if you're going to really look hard and see. Another thing John taught me as a litigator is that you have to be very careful not to create an expectation that something is going to be resolved through some topic where it's not going to happen. So everyone was interested in the 18.5-minute gap. And I remember I said, well, why don't we send people over to Germany? Maybe I wanted to visit Germany, I can't remember, and meet with the manufacturer of the tape recorder to understand, exactly what it would take to erase. And John was not in favor of doing that. And I remember he said, because it's going to create an expectation that there'll be an answer, and it's just not going to happen. You're going to go over there, and there's not going to be anything, and then you'll have created an expectation, and people will be drawing inferences, one way or another, from what you didn't find, rather than focusing on the evidence that really exists. So expectation is important. Obviously, it's important in the political realm, too, of not creating political, but he was talking more about evidentiary expectations.
When do you think you shifted, because it's an important pivot, from being an inquiry to, you say litigating. At a certain point, he's becoming a litigator.
At a certain point, we are presenting a case, certainly when we're drafting articles of impeachment. John, as you know, was reluctant. Certainly the staff never got to take any position. And John was reluctant to take a position. And he did not really do so until just before the vote, where he clearly did take a position. But I think it's not a point in time. It is as the process goes forward. The question is there a case for impeachment under the Bill standard? You start out, you don't know. Is there a case? Is there not a case? You don't know. As time goes by, there's more and more evidence that might be a case. But if you're adopting this approach that John had of needing to see a whole pattern and picture, so as time goes by, the needle, is creeping up in a sense of, is there a case for impeachment? And it creeps up and up. And so as time goes by, you became more certain that there's a case. But then when do you get to the point where you feel clearly and convincingly that there is going to be such a case? I can't remember a specific point. I think it may be about the time I did this list of 50 things. I can't remember the exact date of that list. It was certainly after we reviewed all the evidence, talking to some of the witnesses, listening to tapes. I can't remember the exact moment, but that was a moment too of, you know, the needle having gone beyond that there is a case. I would say I arrived with an expectation, sort of like the committee's expectation, that it would be a quick process to decide whether there was a case, that I wouldn't be down there for maybe a couple months, 3 months, that it would be a quick process. You'd look at things and case, no case, but it really did take this time to do that, both because we, you know, had a process for the comprehensive evaluation of the evidence, and because we had to do other things that meant you couldn't spend all your time just thinking about the ultimate issues. So, for example, I remember one week when I just thought my head was going to explode. There was just so many things going on. I felt that brain pain. Everyone, I'm sure, has felt it. You had an actual pain in your brain from too much, you know, it's somewhere there's another needle in your brain that's over on the red side. And it was because we were trying to get our information ready, trying to think about, you know, what it all added up to. And at the same time, we had to draft justifications for the information requests. We had made information requests that arguably were sort of self-justifying. You read them, and that makes sense. But the committee wanted detailed essays about why this information was needed. So we were doing all of these things in an incredibly compressed period of time, and it caused brain pain. And that obviously meant it was more time than. So I don't see that we could have done it any quicker. I know that 6 months was a long time to have the country dangling, but we couldn't have done it quicker, I don't think, and done it in the way we did it, with the solidity.